Family law was not previously a matter of interest to the European Union, which was centered on purely economic issues. Developments in family law, however, within the European Union in recent years have been truly important. A situation of complete lack of provision in the field of family law has been transformed in a very short space of time by the adoption of several instruments. I should say that this process is not aimed at harmonization of family law at the European level. The objective is to try to find a system of mutual recognition of judgments between the member states of the European Union. There are 4 areas of interest that I would like to indicate during this presentation. The first one is the legislation on divorce, on parental responsibility, on the work on patrimonial aspects of the divorce, and finally, on partnership. I must say that I'm not going to go into the succession regulation. In some member states, succession is a matter of family law, but this matter will be indicated in a different context. Now let's center our presentation on issues relating to divorce. And here I would like to indicate 5 aspects of great importance. The first one is the general aspects and scope relating to divorce. The second one is on jurisdiction. The third one is on the recognition of judgments. The fourth one is the relation with other instruments. And finally, the issue of applicable law that is dealt with in a different regulation, that is the so-called Rome III regulation. Let's begin with the first aspect, and it relates to the general aspects and the scope relating to divorce. This is a matter that is tackled in the context of the so-called Brussels IIa regulation, and in fact is Regulation 2201/2003. 2 aspects should be mentioned in the context of the scope. One is the material scope, and the second one is the territorial scope. Let's start with the territorial scope. Why should we mention this? Because if we have an European Union, the European Union should integrate the whole member states of the European Union. However, we have 2 protocols, protocols number 21 and 22 of annexed to the treaties that creates a special situation. One for UK and Ireland that are included in protocol number 21, and the second one relating to Denmark and is in protocol number 22. So in accordance with protocol number 21, UK and Ireland can make an opt-in to the instrument within a certain period of time, and it did in the context of the so-called Brussels IIa regulation. But Denmark is not in the application of the regulation. And you can see that in accordance with recital 31 of the regulation 2201/2003, it is said that in accordance with the protocol on the position of Denmark, Denmark is not participating on the adoption and application of this regulation. So it means that this regulation is applicable now to 27 member states out of the 28 member states. Let's go to the second aspect relating to the material scope of the instrument. When we speak about material scope, we have to say that we are covering the issues relating to divorce, legal separation, and annulment. So it means that is the judgments relating to a divorce, legal separation, or annulment, or any authentic instrument drawn up in one of the member states that includes matters relating to these aspects. But it should be said that in the regulation, only the dissolution of the marriage linked and not the patrimonial aspects of it are covered by the regulation. Let's go now to jurisdiction, and here there are three elements that should be indicated. The first one is the exclusive nature of jurisdiction covered by the regulation. The second one is the grounds of jurisdiction, and finally the issue of the application of the rules of jurisdiction. Let's start with the first one, the exclusive nature of jurisdiction. In accordance with Article 6 of the instrument, if a person is habitual resident in a member state or is a national of a member state, or in the case of UK and Ireland, domiciled in the sense of the legislation of those member states in one of the member states, then this means that only the rules of jurisdiction are applicable to those persons. The national rules on jurisdiction are therefore not applicable. Now, the second aspect is the grounds of jurisdiction. And here I would like that there are two that are mainly or more important in this context. The first one is those relating to the situation of the habitual residence of the person, and the second one relating to the situation of the nationality. Now, if we look to habitual residence, they are based on a clear connection between the couples and the member state in the order that I'm going to indicate, even if this order is not in a hierarchy, but it can be used by one of the spouses or by the two spouses in the way that they prefer to use. The first one is that the jurisdiction of the courts of the state in which both spouses are habitually resident, so obviously not together. In reality, this ground would cover the vast majority of cases and would be the simplest solution. The second one is where the jurisdiction of the courts of the state in which the spouses were last habitually resident, insofar as one of them still resides there. This situation frequently arises since often in a marriage breakdown, one of the spouses moves his or her habitual residence to another country. For example, to where he or she was last habitually resident and to his or her country of nationality. The third ground of jurisdiction relating to habitual residence is the jurisdiction of the courts of the respondent's habitual residence, which is a general ground for determining international jurisdiction. The fourth is the event of a joint application. Jurisdiction will be assigned to the courts of the member state in which either of the spouses was habitually resident. This limited choice is the only option for choosing a forum open to them. So those are the main grounds of jurisdiction relating to habitual residence. But there is a general second one, as already mentioned, that is nationality, and in the case of UK and Ireland, the domicile in the sense of the national legislation of those two member states. This means that if a person has the nationality of a member state, of the two of them, they have the nationality of a member state, even if they always lived or they had the habitual residence in a certain specific member state, they can go to the country of their common nationality. Take, for example, two Italians that they live in Brussels and they decide to use the court in Rome. They are able to seize the court in Rome for a question of divorce. Finally, there are two or three other grounds of jurisdiction that I would like to indicate. They are more in specific situations, so they are not so general like habitual residence and domicile, and those grounds of jurisdiction relates to counterclaim, conversion of legal separation into divorce, and finally residual jurisdiction. Residual jurisdiction is in situations where the couple or the spouses are living in a third country, and they can use the courts of one of the member states. Now, the third element in the context of jurisdiction that we would like to mention is the application of the rules of jurisdiction in practice. Two elements should be mentioned, highlighted in this context as of today. The first one is the moment a court is deemed to be seized, and the second one relates to lease pendants and relating actions. Now, on the first one, on the moment a court is deemed to be seized, two or three elements should be indicated. First, the regulation takes into account the need to have a dual date system. And this is exactly to take into account the national procedural legislation of the member states that is different. In certain member states, the service of the document is done by the court. In other member states, it is a judicial officer that has this responsibility. And so the member state, in order to take into account and respect the internal procedural law of the member states, takes into account the first moment that the person has received the document or the court has been seized. The second aspect is lease pendants and relating actions. Lease pendants, it's a very known concept, and it means that the first court to be seized is the one that has jurisdiction to examine the situation. However, in the context of this regulation, since we have legal separation in one member state and divorce in another one, or even an annulment in a third member state country, there is a risk of cross actions. And in order to avoid that this risk exists, there's the possibility to create a system of related actions in such a way that is the first court to be seized that has jurisdiction. I give you an example. If you have, for example, one of the spouses goes to a court in Paris and asks for a divorce, and the second one goes to Bonn in Germany and asks for the legal separation. Which of the courts have jurisdiction? Now, the regulation gives a clear answer, and is to say that even if on the subject matter is not the same, divorce on one hand, legal separation on the other, there is a risk of cross actions in this area. And so if the divorce was first seized in Paris, then it will be the court in Paris that will have jurisdiction to take into account the case. Let's go to a different chapter, and the different chapter is on the recognition of judgments. And here I would like to indicate four main elements in this context. The first one is that the recognition of a judgment needs to take into account a final decision taken by a court of a member state. So it means a decision that is not subject to an appeal in accordance with the internal law of the member state in question. The second one is that when you have a judgment given in one of the member states, the judgment is to be recognized in any of the other member states without any special procedure being required. In other terms, if you have a decision that was given, for example, in Netherlands, that decision will be accepted in the Czech Republic without any special procedure being required. This is a very important element, because this will give the possibility that the judgment is quickly, efficiently, and without costs accepted, recognized in any of the other member states. The third element is that the regulation only covers positive decisions granting divorce, legal separation, or an annulment. It means that if the decision by the court will be a negative one, for example, to consider that the spouses are not divorced, such a decision will not be in the scope of application of the regulation, and there are no means for the recognition of such a decision, such a judgment in any of the other member states. The fourth and last element in the context of the recognition of judgments that I would like to indicate is the grounds for refusal. Because in certain situations it is possible to refuse the judgment given by another member state, but those grounds for refusal, they have been harmonized in the context of the regulation in such a way that in any of the member states the possibility of refusing the judgment are identical. Three that I would like to indicate. The first one is public policy, and this one is when a judgment goes against the public policy of the member state in question. Public policy in the context of this regulation, it's a national understanding, it's a national concept, and so it is in that context that public policy should be understood. However, it should be highlighted that the recognition of the judgment may not be refused because the law of a member state in which such recognition is sought would not allow divorce, legal separation, or marriage annulment on the same facts. The second element that can give rise to a refusal of the recognition is the default of appearance by the respondent. This is a very important element and goes in line with Article 6 of the Human Rights Convention. And it's a guarantee for the respondent that all procedural elements are preserved. So this means when the judgment in the country of origin was given in default of appearance and the respondent was not served with the document which instituted the proceedings or with an equivalent document in sufficient time and in such a way as to enable him, the respondent, to arrange for his or her defense, then there is the possibility of the refusal of the recognition of the judgment, unless it is determined that the respondent has accepted the judgment in an unequivocal manner. The last element that I would like to indicate relating to the refusal of the recognition of a judgment is when the judgment is irreconcilable with a judgment in the member state where the recognition is sought. And this can happen in two situations. First, if the judgment is irreconcilable with the judgment given in proceedings between the same parties in the member state in which recognition is sought, or if it is irreconcilable with an earlier judgment given in another member state or in a non-member state between the same parties, provided that the earlier judgment fulfills the conditions necessary for its recognition in the member state in which recognition is sought. So those are the basic elements relating to the recognition. The fourth chapter that I would like to indicate is the relation with other instruments. The regulation shall, for the member states, supersede conventions existing at the time of entry into force of the regulation, which have been concluded between two or more member states, and relate to matters governed by the regulation. Two elements that I would like to indicate. The first one is the Nordic Agreement. Finland and Sweden shall have the option of declaring that the Convention of 1931 between Denmark, Finland, Iceland, Norway and Sweden, comprising international private law provisions on marriage, adoption and guardianship, together with the final protocol thereto, will apply in a whole or in part in their mutual relations in place of the rules of this regulation. The second element that I would like to indicate is that in the relations between member states, the regulation shall take precedent over the Hague Convention of 1970 on the recognition of divorces and legal separations. The last part that I would like to tackle is the issue on the law applicable to divorce and legal separation. In fact, since the Treaty of Amsterdam, the possibility has existed to establish enhanced cooperation between a limited number of member states. However, it was not until 2010 that the member states decided to launch enhanced cooperation for the first time at the European Union level, namely within the area of the law applicable to divorce and legal separation, as we call it, the Rome III regulation. The aim, in fact, is to begin a process of cooperation between a limited number of member states with the prospect that in time all the member states, or a significant number of them, will be able to participate fully in the provisions established by means of enhanced cooperation. The non-participating member states can, however, at all times after the adoption of the instrument, notify the Council and the Commission of their intention to participate in Rome III, implementing, therefore, the enhanced cooperation. Now, in this context, we have two instruments. One is a decision that authorizes the possibility to have an enhanced cooperation, and the second instrument is the regulation that stipulates the rules to be applicable. Now, in the context of the regulation, there are three main aspects that I would like to mention. The first one is scope, the second one is the uniform rules established by the regulation, and thirdly, the exceptions that should be taken into account when applying the regulation. Now, the first aspect is scope, and here scope I would like also to indicate three different aspects. The first one is the territorial scope. In fact, the regulation is binding only to the member states that adopted the regulation or that accepted after the application of the regulation. The regulation was applicable at the date of application of the regulation to 14 member states of the Union out of the 27 by then: Belgium, Bulgaria, Germany, Spain, France, Italy, Latvia, Luxembourg, Hungary, Malta, Austria, Portugal, Romania, and Slovenia. Subsequently, Lithuania joined the group of the 14 member states, and the rules of Rome III should be applicable very quickly to Greece. In terms of material scope, the regulation only applies to the law applicable to divorce and legal separation. Its scope, therefore, excludes situations relating to the consequences of the divorce or the legal separation, as, for example, the name of the spouses, the property consequences of the marriage, parental responsibility, maintenance obligations, governed by the maintenance obligations, and we'll come to this in a moment, and trusts and succession. Now, the last aspect relating to scope is the universal application of the regulation. The regulation has a universal application. It means it should be possible for its uniform conflict of law rules to designate the law of a participating member state, the law of a non-participating member state, or the law of a state which is not even a member of the European Union. I will give you an example. If you have two persons from the United States and they are living in the European Union, they can make use of the system of applicable law in the conditions that are provided for in the regulation and to apply the American law in their case of divorce at the European Union. Very good. Now, the regulation makes some rules, uniform rules, provided by the regulation. And those uniform rules concerns the choice of the law by the parties, the applicable law in the absence of the choice by the parties, and the conversion of legal separation into divorce. Now let's go to the first one. The first one is the choice of law by the parties. And the spouses may agree to designate the law applicable to divorce and legal separation, provided it is one of the following laws: the law of the state where the spouse is habitually resident at the time the agreement is concluded, or, second possibility, the law of the state where the spouses were last habitually resident, insofar as one of them still resides there at the time the agreement is concluded. Thirdly, the law of the state of nationality of either spouse at the time the agreement is concluded, or finally, the law of the forum. Now, it may happen that the parties were not in a condition to conclude an agreement on the choice of law. So, what is the system? What are the rules that are applicable? The regulation provides rules in those cases. In fact, in the absence of choice by the spouses, the regulation designates the system of the applicable law according to a cascade mechanism. First of all, primacy is given to the law of the spouse's habitual resident or last habitual residence, provided that the period of residence did not end more than 1 year before the court was seized, and that one of the spouses still resides there at the time the court is seized. Given the rules of jurisdiction of the Brussels IIa regulation, this choice by the Union law will in practice lead most of the time to the Church applying his national law. Failing this, the law of the state of which both spouses are nationals at the time the court is seized will apply. Finally, the last law which may be applied is the law of the forum. Now, the third type of jurisdiction rules, the applicable law rules that are provided by the regulation, is the conversion of legal separation into divorce. To simplify the procedure, the regulation provides that where legal separation is converted into divorce, it is the law applied to the legal separation that will be applicable to the divorce unless the parties have agreed otherwise. Applicable only in some member states, this system is still in place when it is necessary to take first a decision on legal separation and then on the divorce. There are 3 exceptions to the system of rules on applicable law: public policy, application of the law of the forum, and the third situation is in situations where there are differences in national law. Let's take one by one. The first one is public policy. Application of a provision of the law designated by virtue of the regulation may be refused, not shall be refused, but may be refused, only if such application is manifestly incompatible with the public policy of the foreign. The second exception is in situations of where it is necessary to make the application of the law of the forum. Where the law applicable makes no provision for divorce or not grant one of the spouses equal access to divorce or legal separation on grounds of their sex, the law of the forum shall apply. The third exception is in situations where there are differences in national law, and in fact, nothing in the regulation shall oblige the courts of a participating member state whose law does not provide for divorce or does not deem the marriage in question valid for the purposes of divorce proceedings to pronounce a divorce by virtue of the application of the regulation. Now, after the divorce, legal separation and annulment, I would like to go to the regulation on maintenance obligations. This regulation, regulation number 4/2009 of 18 December 2008, rule matters on jurisdiction, applicable law, recognition and enforcement of decisions, and cooperation in matters relating to maintenance obligations. 7 topics should be dealt with in this context: the scope, jurisdiction, applicable law, recognition, enforceability and enforcement of decisions, access to justice, cooperation between central authorities, and perhaps 1 or 2 indications about other provisions. Let's start with scope, and here we would like to indicate 2 main aspects. The first one is the territorial scope, and the second one is the material scope. Let's begin with the territorial scope. It applies to all member states with the exception of Denmark. However, Denmark is indirectly taking part in the application of the regulation, so it's applying the content of the provisions on the basis of the agreement of 2005 between the European Union and Denmark on this matter. The material scope is very wide, and the regulation shall apply to maintenance obligations arising from a family relationship, parentage, marriage, or affinity. Let's take a look now on the rules of jurisdiction, and there are mainly 4 aspects or 5 aspects that I would like to indicate. The first one is the general provisions. In terms of jurisdiction, which are the general provisions that are applicable in terms of maintenance obligations? And the regulation provides that jurisdiction shall lie with, first, the court for the place where the defendant is habitually resident, or the court for the place where the creditor is habitually resident. So the first 2 criteria are based on the place of habitual residence. And then we have 2 remaining rounds. Is the first one the court which, according to its own law, has jurisdiction to decrete a divorce or legal separation or annulment if the matter relating to maintenance is ancillary to those proceedings. And the second one is the court which, according to its own law, has jurisdiction to entertain proceedings concerning parental responsibility if the matter relating to maintenance is ancillary to those proceedings. The second set of rules on jurisdiction relates to the choice of court. In fact, the parties can choose a court to settle any dispute which have arising between them. However, the regulation provides for a limited number of courts where the parties can go. I will not describe them now, but they are clearly mentioned in Article 4 of the regulation. The third aspect is jurisdiction based on the appearance of the defendant. A court of a member state before which a defendant enters an appearance shall have jurisdiction. This rule shall not apply when the appearance was entered, only to contest the jurisdiction. The fourth ground of jurisdiction is what it is called the subsidiary jurisdiction. The courts of the member state of the common nationality of the parties shall have jurisdiction. Where no court has jurisdiction, including pursuant to the Lugano Convention, then those rules shall apply. We are here in a situation, in most of the cases, where the parties, for example, live in third countries and they have still an attachment relating to one of the member states. The last one is on the issue of forum necessitatis. And it's the first time ever in a regulation that we provide for a rule on jurisdiction relating to forum necessitatis. The courts of a member state may, on an exceptional basis, hear the case if proceedings cannot reasonably be brought or conducted, or would be impossible in a third state with which the dispute is closely connected. In fact, in order to remedy, in particular, situations of denial of justice, the regulation should provide the forum necessitatis, allowing therefore a court of a member state on an exceptional basis, and I underline the word exceptional basis, to hear a case which is closely connected with a third state. Such an exceptional basis may be deemed to exist when proceedings prove impossible in the third state in question, for example, because of civil war, or when an applicant cannot reasonably be expected to initiate or conduct proceedings in that state. Jurisdiction based on the forum necessitatis should, however, be exercised only if the dispute has a sufficient connection with the member state of the court seized, for example, the nationality of one of the parties. Now let's go to the issues relating to applicable law. And Article 15 of the regulation indicates the way to have the determination of the applicable law. And the law applicable to maintenance obligations shall be determined in accordance with the Hague Protocol of 23rd November 2007 on the law applicable to maintenance obligations in the member states bound by that instrument. It should be provided in this regulation that for member states bound by the 2007 Hague Protocol, the rules on conflicts of law in respect of maintenance obligations will be those set in that protocol. It needs to be made clear that these rules on conflict of laws determine only the law applicable to maintenance obligations and do not determine the law applicable to the establishment of the family relationships on which the maintenance obligations are based. The establishment of family relationships continue to be covered by the national law of the member states, including their rules of private international law. And what is the system of recognition, enforceability, and enforcement of decisions? The regulation provides for two systems. One, a simplified one, and the second one, that corresponds to the more classical system of recognition, enforceability, and enforcement in the member states. And why? Because when preparing the regulation, it was make a link between applicable law and the possibility to have an abolition of exequatur. So let's go to the first system, what I call the simplified system. This system implies that there is an abolition of the exequatur. This means that a decision given in a member state bound by the 2007 Hague Protocol shall be recognized in another member state without any special procedure being required and without any possibility of opposing its recognition. A decision given in a member state bound by the 2007 Hague Protocol, which is enforceable, and we are speaking about enforceability and not recognition in that state, shall be enforceable in another member state without the need for a declaration of enforceability. The recognition and enforcement of a decision on maintenance under this regulation shall not in any way imply the recognition of the family relationship, parentage, marriage or affinity underlying the maintenance obligations which gave rise to the decision. This to say, and this is an important element, that the acceptance, the recognition, the enforcement of a decision on maintenance obligations only tackles the aspects relating to the patrimonial aspects and not with the basis of the decision that give rise to the act. Let's go to the second one, what I call the classic system of recognition, enforceability and enforcement. So we have a system of recognition and we have a system of enforcement, and it is necessary to deposit an instrument of a procedure for the enforcement of the decision, and the regulation provides for certain grounds of refusal, of recognition, and I will not go into them because they are clearly described in the regulation. The fifth element is access to justice, and in fact the regulation provides special rules on the right to legal aid. Parties who are involved in a dispute covered by the regulation shall have effective access to justice in another member state, including enforcement and appeal or review procedures in accordance with the conditions laid down in the chapter relating to legal aid. Cooperation between central authorities. The regulation creates a system of cooperation, and therefore each member state shall designate a central authority to discharge the duties which are imposed by the regulation on such an authority. Central authorities should have particularly two functions. The first one, to cooperate with each other, including the exchanging information and promote cooperation among the competent authorities in their member states to achieve the purposes of the regulation. And secondly, seek as far as possible solutions to difficulty which arise in the application of this regulation. Now, there are a couple of provisions that I'm not mentioning in this context, but they are also quite important as public bodies and their functions, authentic instruments, and the relations with other instruments. Let me only say two last issues relating to maintenance obligations. One is that in the relations with Lugano states, it means apart from the European Union, Switzerland, Norway and Iceland, the Lugano Convention provides for a system of jurisdiction, recognition and enforcement of decisions relating to maintenance obligations. The second one is the 2007 Hague Convention on the International Recovery of Child Support and other forms of family maintenance. So it's not the protocol, but it's the convention. And it means that that instrument creates a relation between the European Union, the member states and the third countries. The European Union already made the signature of this instrument and should deposit the instrument of ratification during the course of 2014. I would like to come now to two last proposals that they have a relation in the area of family law. They are not still adopted. They are still under negotiation at the level of the Council on the basis of a proposal of the Commission. Now, those proposals are one relating to matrimonial matters and the second one to partnership. Now, the objective of both proposals is to establish the framework in the European Union in order to determine jurisdiction and the law applicable to matrimonial property regimes and the property consequences of registered partnership and to facilitate the recognition and enforcement of decisions and authentic instruments among the member states. Two proposals, so it means hopefully two different regulations in the future, and both proposals to a very large extent contain parallel provisions. However, the Commission in its proposal on registered partnership decided not to grant partners any choice of courts or choice of law, which has been seen by some delegations as creating a possible discrimination between partners and spouses. However, there are still some fundamental issues that remains to be clarified, including the one that I just referred to, and hopefully we will succeed to have an instrument that gives an answer to the preoccupation of the member states, of the couples, of the Commission, of the European Parliament, and obviously to the citizens in general. Thank you.